Plenary orders. The next court date you will be given following filing a petition and seeing a judge is the return court date to request a plenary order of protection. A plenary order of protection can be granted for up to 2 years, but you can also request it for a shorter period of time. The person you have filed the order against or respondent also has the opportunity to come to this court date. If the person you filed the order against or respondent does not want the order in place, there may be a hearing for the judge to decide whether or not the plenary order should be granted. It is important to prepare for this court date and plan as if there will be a hearing. This is the court date where you can bring any evidence or witnesses you may have that you feel would be helpful for your case. Although you do not have to have an attorney, you may find it helpful to speak with one prior to this court date to ensure you understand all of your options and to see if assistance with your hearing is available. You may qualify for the assistance of local legal assistance at no cost to you. For more information about these programs, please speak to an advocate at the DVAC or court staff. The plenary order is the order that can also outline and order child support and allocate parenting time and significant decision-making responsibility. Parenting time is defined as the time that both parents spend with their minor children. This used to be known as visitation. Significant decision-making responsibility is defined as the responsibility to make important decisions for a child in the areas of education, extracurricular activities, medical care, and religion. The court can allocate decision-making responsibility to either or both parents in each of those areas. Because of this, it is important to think about these topics prior to your court date and have an idea of what you wish to propose to the court. The plenary order may also allow you to make arrangements for exchange of property, and the judge may ask you for a time and place that works for you to exchange property in the presence of law enforcement or an agreed-upon third party. These are also details you may want to think about prior to coming to court for your hearing. If the person you have filed the order against or respondent does not come to court, but records show the person has not been served with the order of protection paperwork and as such was not given notice of the court date, the court cannot proceed with a hearing or enter the plenary order at that time. If you want to continue your order of protection, the court may extend the emergency order of protection if there is one in place and schedule another court date to allow more time for the person to be served. If you come to court again and the person you have filed the order against or respondent still has not been served, you may qualify to have service published in the newspaper. Please speak with an advocate or court staff for more information regarding service by publication. Conversely, you may decide you no longer want the order in place. If you no longer want the order, you can inform the judge at your hearing date that you do not wish to continue the order, and at that time, the emergency order of protection may be terminated, resulting in the case being dismissed. If you do not come to your plenary order of protection hearing, your case may be dismissed and the emergency order of protection will expire. This will happen whether or not the person you filed the order against comes to court. If you, the petitioner, do not appear in court, the case will be dismissed. If your request for a plenary order is granted, you will receive copies of the order. Keep the order of protection with you at all times. It is also important to drop off a copy of the orders at all of the protected locations included in the order, such as a school or place of employment, so that they have that information. If the person you have filed an order against or respondent appeared in court, they will receive a copy of the order at that time and will not need to be served by the sheriff. If they did not appear in court and your order was granted, the paperwork will be sent to the sheriff and the person the order is against will be served by the sheriff. In Winnebago County, you can receive text notifications when the order is served and can also contact the Sheriff's Department for further information about service. Please speak with an advocate or court staff for this information. If both you and the person you filed the order against appear in court and a hearing is held to decide if the order should be granted for a longer period of time, it is possible the judge may decide to deny your request for a longer plenary order. You will no longer have an order of protection in place. What if the sheriff cannot find the person to be served with the order? The sheriff will continue to try to find the person the order is against to serve them, but there are times the person cannot be located and therefore cannot be served with the order. If the sheriff is unable to locate the person to be served, you can request that the court allow you to publish notice of the order of protection in the newspaper. This is called notice by publication. The court may extend your emergency order of protection while the notice for the order is published in the newspaper, and the notice must be published 3 weeks in a row. If the court grants you permission to provide notice by publication, the clerk's office will submit the necessary information to a publication of their choice, and this is done at no cost to you. You will then have a return court date about 6 weeks from the date leave for publication is granted. If the person the order is against lives outside of Winnebago County, the paperwork will need to be sent to the sheriff of the county the person resides in. This is called out-of-county service. An advocate or personnel from the clerk's office can provide you with additional information on how to complete out-of-county service.